And good afternoon, everyone, and thank you for attending the Lawyers Risk Management webinar. This is part of our Professional Liability Insurance webinar series and focuses on sample law firm policies. Today, my name is Neil McGowan. I run our McGowan Pro Specialty Liability Division that focuses on, among other things, attorneys. So we only focus on professional liability insurance. We're a fourth-generation family company. I actually have practiced law in the past prior to joining the company and now focus exclusively on this professional liability division. So we'll jump right into it today. We're going to talk today about a couple of things, but really focusing on policies that should be put into place for law firms practicing. So the first thing I'd like to mention, really talk about is general risk management policies, and that includes the necessary part of an effective law firm office management, and that's to have policies and procedures in place for a docket and calendar system. Ideally, truthfully, the firm should maintain a centralized firm-wide docket and calendar system. Some of our firms out there do utilize separate systems for different practice groups, but for those separate practice groups, we do have a centralized system for each individual practice group. Whatever system the firm uses, it definitely should be computerized. So the firm should provide a backup of the docket system and calendar data, and the backup data should be stored off-site, basically so that if a disaster happens or the power goes out or your office, God forbid, burns down for a couple of days, you're going to have access to that off-site data, and that allows for redundancy. That also leads into something that we'd like to talk about, which is PDAs. So you shouldn't just have one calendar system. Ideally, a firm should maintain a computerized calendar system, but also use either a written calendar system or, a lot of our firms are using PDAs. So if you have an iPhone or an Android that has a calendar system built into it, that way, individual firm attorneys are able to quickly reference that firm, that data from the centralized calendar, and able to look at that quickly rather than being on site. The big thing we like to tell people is to make sure that with cell phones, with any sort of PDA, you're using a synchronizing setting so that the PDA synchronizes back to the central docket system, the central calendar system. You don't want to make a change to your cell phone and then realize all of a sudden that you forgot to add it to your central calendar when you're working on your computer. Typically speaking, a lot of people are using Outlook. They enter the calendar in one place or the other and then sync it out remotely. So the big thing that we like to talk about, make sure you have a master calendar of deadlines. That includes, you need to make sure that the docket system incorporates the following deadlines right up there on the screen: your statutes of limitations, your pleading deadlines, court dates, discovery dates, opposing party deadlines, and all of your appointments and meetings. If you have a litigation practice, we also recommend that you include all pleading deadlines, all court filings, court dates and appearances, and all discovery dates and opposing party dates. If you have a tax, trust, or estate group, we recommend a docket calendar system that includes all tax return filing dates and all litigation deadlines. If you have a real estate practice, we're recommending that you include all contract deadlines, all loan and documentation deadlines, all inspection and due diligence deadlines and closing dates. We actually have a recommendation list for any of the firms that we use, the different types that we include in addition to these standard requirements and calendar systems. So if you have any questions after this, you can shoot us an email or ask a question in the webinar. We'd be happy to answer that at the end or send you out that information privately. Finally, we want to make sure that you're using written reminders of the deadlines. Depending on the firm size, you should have one person at the firm who gives reminders to the attorneys prior to any critical deadline. And typically speaking, we recommend that you have 3 reminders prior to the arrival of any critical deadline. And you should also have a backup person at the firm who would be able to provide those deadlines in the event that someone is out, on leave, or injured. Finally, we always like to say that your docket and calendar policies should be in writing. So we actually do have a sample policy that we can provide to all the attendees today. And what it does is it's a recommendation to put all of your docket and calendar in writing, preferably in a manual of firm policies and procedures, to make sure that all lawyers and employees are aware of the policy at your firm. And we also want to make sure that we recommend that whenever an attorney joins a firm, so you have a new attorney on board, that you communicate this to them in a formal orientation program, and also communicated at least annually during training sessions. So the next thing we're going to talk about is your group management of client matters. Now, this is for the larger firms out there, but we want to make sure that whenever a client comes in the door, any new client matter, that it gets assigned to a practice group and then a new file is opened in that practice group. The practice group should include a partner, your associates, paralegals, and really the benefit of this is that the firm structure, or building this into the firm structure, is that it ensures quality in the handling of cases. Typically speaking, by creating this structure, if you have enough attorneys at the firm, the problems and errors get caught in an early stage before they reach that crisis stage, and it can ensure profitability because it ensures that every file is being worked on regularly. So this actually leads into the supervision being critical in this phase. Really, supervision with a practice management is vital. It ensures that lawyers aren't acting really as going rogue, not going rogue, and not acting as lone wolves, acting without oversight. It provides the firm the ability to ensure independence, and it protects the firm from any damage that can be done by, in client matters that are inappropriate. So we also recommend that these practice groups meet regularly. The frequency really depends on the area of practice. Some groups will need to meet far more regularly than others. From a general policy perspective, we do like to mention the giving of gifts and receiving gifts really, because it leads to issues with the firm in terms of questions really creating conflicts of interest among clients of the firms. So it's essential basically that you, without prior approval of a designated partner of the firm, no attorneys or employees of the firm give any judges, court employees, representatives of the press or any sort of electronic media, clients, their families, other than a pre-approved holiday gift program, or claims adjusters or claims handlers gifts. For the same reason, we don't want to give out political contributions unless it's been approved in writing by a designated partner at your firm. And for the same reason, you don't want to give out charitable donations without pre-approval from a partner of the firm. It's incredibly important because you could end up creating situations with conflicts of interest, or, for instance, if a law firm typically represents real estate owners, if the attorneys are giving gifts to a fair housing client or charity, it can lead to that conflict and the appearance of conflict, which can lead to problems with your clients, even if it's not a legal conflict of interest. Finally, we want to make sure that you don't have anyone in your firm preparing any estate documents for any family members or any spouses. Really, anyone within 3 degrees of separation is the best risk management practice. So one of the other things we like to consider is your investment in clients. Investing in clients is something that quite a few of our attorneys do. However, there's significant risk of the investment, including that you can lose the investment, but there's also problems with if a law firm, for instance, goes into a public offering and it's an all-or-nothing approach, it can lead to the law firm filing it can lead to the client filing a complaint, which would ultimately lead to problems for the law firm. It can also create issues with any sort of claim back against the law firm. So we, as an insurance underwriting company, like to look at the relationships and what investments the attorneys have in clients so that we can evaluate whether or not it's something that we would want to cover in the event of a claim. So just be aware that investing in clients can actually affect your errors and omissions insurance and whether or not there's coverage. So we're going to move on to our computer, internet, and social network management section. Before I really get into any of this, I did want to address a situation that we had come up recently, which is redacting information properly. So with digital tools, a lot of times removing information from documents isn't what you think it is. We just had a situation come up with a claim where a member of the firm had used black bars to cover up wording in an Adobe document. She then forwarded that document to opposing counsel, and when opposing counsel got them, he clicked on the black bars, hit the delete key, and all of the supposedly redacted information had been completely made visible. This obviously led to some issues with the firm, led to some issues with the client. So I just wanted to address this quickly. If you're going to just be using the black bar tool with Adobe and then sending out digital documents, there's a tool out there called the Flatten tool. And what it does is it takes away the layers in the Adobe PDF and allows you to actually completely remove any layers that you can delete so that all that documents get sandwiched and unable to be removed. The best thing to do, though, is to actually delete out the stuff that you don't want to pass along. So you can edit the PDF document if you have the Pro version of Adobe Reader. It's actually Adobe Acrobat. And if you don't have it, we recommend that you print out the document, either white or black it out, and then scan it, and then put it into your computer. We do want you to be aware that when you do black it out with a marker, sometimes when you do send that later on, if someone prints it out and holds it up to a light, because of the way that the scanner works, it can actually differentiate between the two different types of black, and you can sometimes still read. So the key is that you don't leave any metadata in the document that you don't want to send on. That's any information that is beyond what's visible. So if you have any questions about that, we're happy to discuss that with you later on. But we'll get right into our policy on firm computers, internet use, and social networking. So as I discussed earlier, we actually have sample policy forms that you can use and provide to your law firm in the event you have these questions. But right off the bat, we like to just kind of, from a high level, address the topics that we put into these policies. The first thing is ownership. So computer systems in the policy have to be written down that they're the sole ownership, the sole property of the firm, and that when a staff person or attorney leaves the firm, he or she has to surrender all computer equipment. This has led to some issues with maintenance of client files down the road. It's just very important early on to establish that with any attorneys or new attorneys you have come on. You also want to establish that the computer system is not for personal use. So the systems are to be used solely for business purposes. We do put a small caveat in the policy saying that occasional short informational messages of personal nature or short use of the internet for personal purposes is allowed, but you do want to put that in there just in the event that something comes in down the line that could lead to a problem for your firm. The next thing we want to talk about is the use of computers and equipment by third-party non-members of the firm. Right off the bat, you have to say that's absolutely prohibited. Allowing someone who's not a member of or employee of the firm to use a computer is essentially giving them access to review all of the firm's files. Whether or not they have any access, whether or not they're using, just browsing Facebook, by the very act of giving them access to a computer is the same or equivalent to allowing them to review your files firms. So it has to completely include not allowing any member of the public, anybody outside of your firm, to use the firm computers. We also like to include a section on the content of emails, essentially saying that, and this should be pretty standard practice, but it's always good to have it in writing, that no one can use the computers to access or to disseminate information that constitutes verbal abuse, insult, slander, defamation, any sort of disparagement of any employees, customers, vendors, the competition. We also like to say, content of a sexual nature should be completely prohibited, and employees should use caution and common sense. Essentially, make sure that employees understand that the content of any emails, anything they do on the computer systems, can be reviewed and will be reviewed by management. And that way you ensure that no one is doing anything untoward or inappropriate using the company's firm's materials. Along those lines, we also want to make sure that whenever you are dealing with sensitive material, that it is always encrypted. We've had issues where someone has left a laptop, in a coffee shop, and unfortunately, someone else has picked it up, and by failing to encrypt the data, people have been able to remove the hard drives and put them into other computers. It's a real problem, so we do highly recommend that you encrypt all of the data on your computer, all the data on the hard drive, so that even if you had a break-in into your office, someone who took that hard drive would not be able to use the data on it. Likewise, with virus protection, this is a common sense thing, but as a matter of policy and put into that written policy, you should place that you should never open an email attachment unless you know who the person sending it is, and that you understand and expect that document is coming. If you ever receive an email attachment that you don't know who it's from, even if it looks official, we always recommend that you independently pick up the phone and call that office. So don't call the number that's in the email that you received. Search the number, find it in a phone book or search online, and independently verify that information before you pick up the phone, and then verify that you were supposed to receive it with the attachment. We've had a lot of issues recently with virus attacks where someone will open up that document and it will infect the entire network and shut down a law firm for a day. But the scarier thing is no one knows that the virus is on the network, and then all of a sudden they have access to client files, any mergers and acquisitions that are coming up. It can be very detrimental to the firm. So we'll briefly talk about social networks as well. Essentially what you want to put into your policy at the firm is that social networks, personal pages on social network sites cannot in any way purport to be maintained or in any way connected with the firm. You can tell your employees that it's completely fine to tell them that you work for the firm, but it has to make clear that any of these views on there are personal views, and we do like to say, remind your employees that any information that's put on the internet, once it's out there, there's no bringing it back in. The number of times it's happened where someone has posted a picture or said something detrimental about an interaction they had with a client in a day comes back to bite the firm, whether it's a law firm or an insurance company, it happens all the time. So we just like to make sure you're aware of that and put that into your policy regarding social networking. So now we're going to talk about your online activity, and this is kind of the next step. Basically, again, you just want to remind your employees that if they place it on the internet, it can be copied, forwarded, and subpoenaed. You have no control over the post's ultimate use or dissemination. There's always the risk that when someone posts something, even inadvertently, that it will be brought up in a trial later on down the road, that it will harm your client, and that will lead to a claim. So make sure to just address that with your clients right off the bat. If there's any questions about it, you want to have a designated person who that employee can come and say, can I post this? And generally speaking, if they have to ask the question, the answer is no. You want to hold those people personally responsible for their online activities, and you want to make sure that in any online activity that they're respecting the privacy, opinions, and interests of your clients, colleagues, and others online. There are times where it feels really good to have a witty response to someone, but in the long run, it's actually damaging to the firm. So make it part of the policy that respect for clients and respect for colleagues and even respect for other firms is built into it. That way you don't run into problems down the road with lawsuits. But really what's most important is protecting your clients. So you as lawyers have a broad obligation to protect your clients and firm confidences, and that includes a duty to protect client information. That's even when the information is otherwise publicly available. So under no circumstances should anyone at your firm use or disclose directly or indirectly client-related information, even including that the firm represents a client or filed pleadings without the express permission of the affected client and also of the firm. That goes even further when we're talking about respecting their privacy. So a lot of times we'll see on LinkedIn, you'll receive a request of a friend, connect, or link to other social network users. So you want to make sure that in the policy for the company, you state that under no circumstances should an employee or attorney post or share any of that information online. And that includes do not allow anyone to upload the firm contact list or their email contact list to a social networking site, because that can actually expose your contacts to outside review, and it can allow third parties to know who is a client of your firm. That said, you also want to think about connecting, who you're going to be connecting to, and you want to make sure that you don't give legal advice to someone who is not otherwise the client based solely upon an online post. So if you do believe that it's appropriate to provide general guidance, we always recommend that you put a disclaimer on the general guidance, essentially saying that you don't know all the relevant facts, so you can't give legal advice, and they should consult their own attorney. However, from what the person has written, it sounds like yada, yada, yada. Also, if you're not licensed in that jurisdiction, you should always warn of that fact prior to giving any advice, and truthfully should probably avoid doing so. So we'll move on to the next one. So this is part 2 of that. One of the biggest things that we run into is that people will give legal advice online prior to running a conflict check. You'd be surprised at how many times it ends up biting the firm. It does happen where someone posts a general question online, and by failing to run the conflict check, you have an attorney who is actually given legal advice to opposing parties. That's very problematic for the company, so make sure to post that if you're going to be going onto any of the lawyers' websites where you can post an opinion or respond to questions, that your attorneys have to run a conflict check first. Also, the rules of professional conduct do govern advertising and solicitation, and even they run, if you're going to respond to those questions, it can create a problem. So if you do realize that you've made a mistake in an online post, apologize and correct the mistake right away, and then move on, and make sure you're not posting any false or misleading statements while posting online. Having said that, once you have posted online, if there's anything about a client conduct or client matter that you're dealing with, the rules of professional conduct, as well as malpractice concerns, really require that a lawyer should maintain a copy of all communications about the lawyer or the services for a period of at least 2 firms. Now, you definitely have to confirm with your state's version of the ABA Model Rule 7.2 and 7.3 is appropriate. But again, make sure that you arrange that any access to firm-related communications you post online is maintained for a period of at least 2 years. So now we're going to talk about record retention and consideration. Really, this varies by jurisdiction. ABA Model Rule 1.15a contains a provision that complete records of client trust account funds and other property shall be kept and preserved by a lawyer for a certain period of time after the termination of the representation. In Florida, it's required that it's 6 years. In Illinois, it's 7 years. So you definitely have to check your local jurisdiction. But we would tell you in terms of what needs to be maintained, the discovery rule is very broad. So you have to retain any document that was important to the lawyer to have in writing in the first instance. That includes retainer agreements, correspondence regarding important events, copies of materials documenting the conclusions of legal matters, billing materials. This all documents your lawyer's compliance with the standard of care and resolve future questions of representation. And it's also can be property of the client. So the goal is check your local rules, verify the amount of time you have to maintain them. But again, 6 or 7 years is pretty standard in the market. So what else do you have to maintain? Right off the bat, you do have to maintain emails. You have to maintain electronic documents. You have to maintain memoranda and correspondence and any other record that's scanned or placed in your computer systems. If there's a litigation hold, you have to hold it for even longer. But typically speaking, what we say is create a retention and destruction schedule of electronic documents, which includes email, which has the same timing as the destruction of standard paper records. So when you are deleting the paper records, if it's been long enough, you're deleting those at the same time as the electronic data. And then we like to talk about disaster planning. You should have a plan in the event something goes wrong. So you want to have someone designated at your firm to be responsible for implementing the policy. You want to have someone appointed and trained for emergency response team, including the assignment of persons to assist others who may need assistance. You need to establish a system of communication to contact a senior staffer if a disaster occurs after normal working hours. You should be able to identify the potential causes of disaster for your company. In California, we're having big issues with fires. So when a fire burns down a local office, we're running into issues with people not being able to access their calendars, not being able to access their files. So what you want to do is make sure to have an off-site system to be able to have that backup and be able to access all those documents in the event your system is unable to be accessed. So finally, just a quick discussion about the benefits of insuring with McGowan Pro. So McGowan Pro is the exclusive insurance agent for Zurich, which has an AM Best A+ rating. We tailor our programs to fit the needs of both of solo, full-time attorneys, part-time attorneys, moonlighting attorneys, and small to medium firms. Our goal is to really write in the 1 to 25 attorney range. We're not looking for the largest firms out there. We do have incredibly fast turnaround times on insurance quotes. Typically speaking, within 3 days we can get you a quote. But if you do need those quotes same day, we can absolutely get those to you. We include access for our clients to loss prevention hotlines and the ability to access lawyeringlaw.com, which really does a great job of helping with a lot of these policies that we just discussed today, and that's handled by Hinshaw & Culbertson, LLP. We have 24/7 claims reporting, and something that I really like to talk about here is the fact that Zurich claims handling is some of the finest in the industry. So essentially, all of the claims staff are JDs. They're all attorneys. They've all practiced. I think all but one practice, and all of them have their JD. So these are real attorneys who know what you're going through, who can assist in the event a claim occurs, and they can guide you through their, any questions or problems you might have. And then finally, I like to tell people Zurich has been consistently in the lawyer's professional liability market for 25 years. McGowan has been administrating insurance policies since the early 1900s. So what you're getting between the two of us is a lot of experience, a lot of expertise, and really the ability to help you build your business and protect your business. So, having said that, I think we'll wrap up. Does anyone have any questions? I'll pull that up really quickly. I'll give you guys a couple of minutes to post those questions. All right, and it appears most of the questions are looking for sample policies, the sample policies and procedures that we discussed today. So what I'm going to do is after this, we'll individually follow up with each of you, and we'll make sure that you get a copy of each of those sample policies and procedures. And if you have any questions after that, please don't hesitate to reach out to us. But otherwise, thank you so much for attending. We really appreciate it, and we will talk to you shortly.